Good morning, this is your Kelso Report for Thursday, March 15th, and I'm your host, Clark Kelso. Today we have cases involving environmental regulation, what it means to award just costs, the case involving the Federal Tort Claims Act, election law, habeas, and health law. Quite a wide variety for this morning. Let's get started with two environmental law cases from the Ninth Circuit. There has been a long-running dispute about the apparent recovery of gray wolves in the Rockies, and about whether the gray wolf should still be listed as endangered. The government had previously tried to adopt a partial delisting that would be applicable to a distinct population of gray wolves located in the northern Rocky Mountains. That effort was challenged in court, and a district court previously held that a partial delisting was unlawful under the Endangered Species Act. While that case was pending appeal, Congress enacted Section 1713 of the 2011 Appropriations Act. It orders the Secretary of the Interior to remove a portion of a distinct population of gray wolves from the protections of the Endangered Species Act without regard to any statute or regulation that might otherwise apply. Section 1713 was immediately challenged as an unconstitutional attempt by Congress to specify the result in pending litigation. Well, in Alliance for the Wild Rockies versus Salazar, the Ninth Circuit rejected that argument. While it is true that Congress may not compel a court to adopt a particular rule of decision with respect to a pending matter, that's what the Supreme Court held in its 1871 decision in United States versus Klein, it is also true that Congress can amend existing law in such a way that, as applied by a court to a pending matter, changes the result in that case. That's what the Supreme Court held in its 1992 decision in Robertson versus Seattle Audubon Society. It was Robertson versus Seattle that applied, according to the Ninth Circuit. In short, what Congress giveth, Congress can taketh away. Our next case involves turtles. In our first case, Congress had changed direction, and the court upheld the change. Now, in our second environmental case, Turtle Island Restoration Network versus Hawaii Longline, the administration changed direction after a new president came into office, and the court upheld the authority of the new administration to change the result in a pending case, this time by entering into a consent decree with the plaintiff that, by and large, gave the plaintiff a substantial part of the relief it was seeking, over the objections of industry representatives which previously had been aligned with the Bush administration. The politics were not mentioned at all in the opinion, but that's pretty clearly what happened. Essentially, a new rule had been adopted by the Bush administration dealing with regulations pertaining to longline fishing for swordfish. Among other things, the rule raised the incidental take limit for certain endangered turtles. The new rule was challenged. Ultimately, the new administration decided to settle with the plaintiffs, and the court entered a consent decree that ordered vacatur of the new rule. Well, by operation of law, the previous rule then became applicable, and it was more restrictive on the incidental take limit as well as several other issues. The industry tried to argue that use of a consent decree to modify regulations violated the Administrative Procedure Act and the Magnuson-Stevens Fishery Conservation and Management Act, which contained special rulemaking processes for certain fishery regulations. The Ninth Circuit rejected that argument, both because the government has broad authority to manage its litigation and settlements of preferred resolution, and because the so-called new regulation was actually the previously enacted regulation, which, as a matter of law, became applicable upon vacatur of the more recent rule. That prior regulation had itself been properly promulgated, so the consent decree was not being used to adopt new regulations without appropriate public input. Our next case involves the question of what constitutes just costs under Title 28 U.S.C. 1919. When a case is dismissed from federal court for lack of jurisdiction under Section 1919, the court, quote, may order the payment of just costs, close quote. Now, the language in Section 1919 clearly does not require costs to be awarded to a prevailing party, and the Ninth Circuit in Otay Land v. United Enterprise held that the phrase just costs gave the district court discretion to consider a range of factors in deciding whether it was fair and equitable under the totality of the circumstances to impose costs. The district court in the case had awarded costs essentially based on a prevailing party standard. The Ninth Circuit held that was not the proper legal standard and remanded for reconsideration. If you are wondering why the parties are arguing about costs, it is because the jurisdictional defect was not discovered until after quite a bit of discovery and a motion for summary judgment had been filed. Costs in the case were around $275,000, and that is certainly enough money to litigate about. Next, we have a case under the Federal Tort Claims Act. The Federal Tort Claims Act makes the United States liable, as you know, for certain torts of its employees acting within the scope of employment. In Sharrock v. United States, the plaintiff was injured in an automobile accident by a car driven by an off-duty sailor whose negligence in the accident was conceded. At noon on the day of the accident, the sailor was given the rest of the day off. Later in the afternoon, he was driving in his own car to a basketball practice at a facility furnished by the Navy as part of its morale, welfare, and recreation program. Well, after reviewing the applicable law of agency, including the going and coming rule, pursuant to which commutes are generally outside the scope of employment, and the special errand rule, pursuant to which an employee can be pulled back into scope to perform specially requested duties for the employer, the Ninth Circuit panel held that a service member en route to participation in a recreational activity where participation is encouraged by the Navy but not required, that person is not acting in the line of duty. And the panel then affirmed the district court's dismissal of the complaint on the government's motion for summary judgment. Next, an election law case from Nevada. Nevada state law permits direct legislation through ballot initiatives. And to qualify an initiative for the ballot, proponents must obtain signatures from a number of registered voters equal to 10% of the votes cast in the previous general election in each of the state's congressional districts. This geographic distribution requirement was challenged on equal protection and First Amendment grounds, and the district court held that the state law requirement was constitutional. In Angle v. Miller, the Ninth Circuit affirmed. The applicable case law establishes that geographic distribution requirements assigning equal political power to districts of unequal population, that violates equal protection. But the Nevada law uses congressional districts, not counties, as the geographic metric, and those districts do have equal populations for voting purposes. Accordingly, the Nevada requirement did not violate equal protection. As for the First Amendment claim, the plaintiffs were simply unable to establish factually that the rule actually imposed a substantial burden on access to the ballot. And absent evidence of that burden, the state's justifications for the geographic distribution requirement were sufficient to survive the rational basis level of First Amendment scrutiny. Next, criminal law. The defendants were convicted in federal court of bulk cash smuggling under 31 U.S.C. Section 5332 and failure to file reports on exporting monetary instruments under Section 5324. Border agents had found a bag containing $500,000 in cash in a box hidden under a sheet in the back of the defendant's van when they were making an early morning border crossing. The defendants asserted that the evidence of their knowledge of the cash was insufficient to support the convictions. There was instructional error, there was prosecutorial misconduct, there was cumulative error, among other things. On the sufficiency argument, although there was no direct evidence of the defendant's knowledge, the Ninth Circuit held in United States v. Del Toro Barboza that there was sufficient circumstantial basis to support the conviction. After all, they were carrying $500,000 in a box that they had themselves loaded in the van, and the defendants conceded that they knew they were carrying some form of contraband. The jury was entitled to draw reasonable inferences from the evidence. Now we turn to the state intermediate appellate court's first habeas case. In the last several years, the Board of Parole Hearings has fallen into a habit of frequently rejecting parole because the inmate ostensibly lacks insight into the factors that led him to commit his crime. The board often seems to come to this conclusion, notwithstanding what appears otherwise to be an exemplary record of behavior in prison. In In re Andrew Young, the First District took a shot across the bow of the parole board by granting a writ of habeas corpus and remanding to the board for reconsideration. The basis for the remand was the court's conclusion that the board applied the wrong legal standard by focusing too much attention upon the legal insight issue and not paying sufficient attention to the other factors that the statute requires be taken into consideration, including petitioners taking responsibility for the commitment offense and remorse, exemplary prison record, extensive rehabilitative programming, positive psychological evaluations, concrete parole plans, and significant support from family and friends. In addition, the majority found the board's decision rested not on the record, but on incorrect factual contentions and guesswork. So the majority held the board's decision violated due process. There was a dissent here that argued the majority had failed to review the board's decision pursuant to the appropriate standard of deferential judicial review. Now, because of the dissent and the majority's conclusion regarding the excessive emphasis on lack of insight as a basis for denying parole, I would not be at all surprised to see the California Supreme Court take this case up for review. Our final case is a health law case, Scott S. v. Superior Court, where the Superior Court authorized the public guardian for Orange County to consent to amputating the petitioner's infected toe. In making the order, the court relied on a physician's written declaration to find the amputation was medically necessary. The petitioner challenged the order on the ground that an order authorizing consent to surgery can be made only on the basis of admissible evidence of medical necessity, and the declaration was inadmissible hearsay. In Scott S. v. Superior Court, the Fourth District agreed with the petitioner. While a finding of medical necessity is not required for certain types of medical activity, the law clearly requires a finding on medical necessity for surgery, and the public guardian conceded that the declaration was inadmissible hearsay on the issue of medical necessity. The court's conclusion was supported by the language of the Lanterman-Petrus Short Act and harmonizes that act with relevant portions of the probate code. And that's it for today's Kelso Report. Have a great day in the law.